This is Michael Popok, Legal AF. The merry-go-round at Mar-a-Lago continues with an out-of-control judge who has no handle on or discipline of the courtroom or any of her proceedings. We have a debate, Karen Friedman Agnifilo and me. Her with her 32 years of prosecutor experience, mine, the 32 years of defense experience. Our debate focused this past midweek on whether all of these motions and denial of motions and adjournments and postponements, and I'm taking my gavel and going home, by Judge Cannon in the Mar-a-Lago case is benefiting Donald Trump and helping him with his ultimate goal, which is to push this case off in the criminal trial of it well beyond the November election. Hopefully he'll have a lot of time on his hands after the November election. It won't be planning anything, but at the very least, he doesn't want that trial now. And the question is whether he's found a friend in Aileen Cannon, the judge down in Fort Pierce. Karen and I take opposite tacks. Take a listen. You and Ben have become the masters of the SIPA universe and Judge Cannon. Why don't you talk about a couple of things that have happened down there? And I've heard your opinion on the hot take, but share it here about why you think this all kind of is a conspiracy by the judge to ultimately rule that this trial of hers is not going to happen in May before the election, as we suspected. And I'll listen to it and maybe I'll have a counterpoint.
Yeah. So look, I think, and I've said this since the beginning, that Judge Aileen Cannon is going to, when she ruled that the trial is going to be May of 2024, as opposed to after the election, we all said, let's see if she sticks to that. She's never going to do something ridiculous like say, oh, it's going to be years from now or after the election, because that she'll get criticized. So instead she'll set a date, but then we're going to see these little teeny, I keep calling it death by 1,000 cuts, right? You're going to see all these things. Okay, you have to do this by this date, but I need 5 more days, Judge. Oh, okay, you can have 5 more days. Or I need 2 weeks, Judge. Okay, you can have 2 weeks. And over time, those all add up. And I think we're going to potentially see that trial date get moved because she's constantly allowing that to occur. And the SIPA issue that you're talking about has to do with discovery. And one of the issues is the defense attorneys are saying, we don't have all the discovery. We want to see all of the classified documents, and we haven't been provided them all. They've been provided many of them, but there's a few that are so highly sensitive that Jack Smith and his team are saying, look, we want to provide these, but we think they're so secretive and so sensitive and such, highly classified, the super top highly classified, that we can't even they can't travel. They need to stay in Washington, and we want to put it in a SCIF. That's the room that's so secure that allows radio waves can't come in or out. You have to leave your devices at the door. I mean, it's these certain these SCIFs they're locked, and they're very. It's where you can view things that are highly confidential and not worry that this information can leak out. And so they said, there's one in Washington. We want those documents to be there. Of course, the defense attorneys are saying, no, it's inconvenient. We want it to see it in Florida. And Judge Cannon says, okay. And so she ordered that all of the documents have to be put into a SCIF in Florida and in the Southern District of Florida. She was very specific about that. And so we'll see what happens. We will see if, at the end of the day, if Jack Smith can find a way to convince the intelligence community that there's a safe way to bring that down there, or they could potentially dismiss whatever counts have to do with those particular documents. And look, the SIPA, the Classified Information Procedures Act, the whole point of it is it's to prevent, they call it gray mail on the part of defendants. And what that means is you don't want to be blackmailed because somebody steals your most secret documents, and then you go to trial, you get prosecuted, and they say, oh, well, guess what? My due process rights means you have to put into evidence what I stole, what you allege that I stole in order to prove your case. And of course, the national security community is going to say, well, we can't do that. We can't put the nuclear codes in evidence. That would put everyone in danger. So it's sort of a way of preventing this blackmail or gray mail. The Congress passed the Classified Information Procedures Act many years ago. And it essentially says, look, yes, due process normally requires that you have to be anything they want to use against you has to be introduced into evidence at trial. But when it comes to classified information, we're going to make an exception. And there are procedures in place that you can determine exactly what the process will be, so that on the one hand, your due process rights are met, but on the other hand, national security is also taken into consideration. So you do things like you can sanitize the documents, you can redact the documents, you can summarize the documents, you can, there are things you can do that you can make it so that you can still go to trial and utilize aspects of the documents. But these particular subset of documents are so sensitive that they're saying they cannot travel. So it'll be interesting to see exactly how Jack Smith deals with it and what he does. But that's where we are with the with the SEPA situation. But again, the discovery, between that and the Garcia hearing that has been happening, that was adjourned for Walt Nauta because, the Garcia hearing was the conflict hearing to see if Stan Woodward can represent him, even though he's represented multiple other witnesses. That got adjourned because the defense said, oh, we're surprised. There was an argument that was made that's new. It wasn't in the papers. And Judge Cannon's like, oh, you cited to a case that's not in your papers, and you're making these arguments that you didn't raise before. You wasting my time, adjourn the case, which is so ridiculous, because that to me just shows her inexperience, right? This is a Garcia hearing. It's to determine conflicts. It's to determine whether or not there's a conflict of interest in, you represented this witness that you claim you want to cross-examine, Stan Woodward. That witness told you things in confidence with the attorney-client privilege. How are you going to possibly cross-examine them? And so, but she's inexperienced, or she's, doing this stealth Donald Trump bidding for him and doesn't want to be overt about it. I don't know which one, but the fact that she thinks that new issues were raised at the hearing, I think just shows her inexperience. Because, anyone who's ever had a hearing before the court, that's where the facts are developed. That's where the arguments are developed. The papers definitely are part of it, but you further develop it at the hearing. That doesn't make it new or novel in order to be adjourned. So I'm just concerned that she's allowing the defense attorneys who want delay and who don't want this trial to go quickly, she's allowing them to push this so that it could potentially not happen in May.
I've had judges where I've lost every discovery motion and then some leading into a trial. And then at trial, I won everything that mattered, including the trial. And if you had asked me at any given moment during a case, what's going on? I would say, oh, this judge is against me. Or an arbitrator. Every decision went the other way, to the other side. You think the fix is in. I'm going to lose this. And one of the reasons they bend over backwards is because, they don't want any argument on appeal that they didn't accommodate or rule in their favor, kind of sweeping away any appellate holes or exposures. And then, especially if your case is really, really strong. And I think there is an argument, and I know we like to say that on this network that she's corrupt and she's incompetent and she's over her skis and the fix is in and she's a Federalist, all potentially true. What also could be true is that she's holding the prosecutor's feet to the fire where they have the burden of proof. And for what she's seen so far from the pleadings and the things that have been presented, there seems to be an overwhelming amount of evidence in favor of the government and against Donald Trump. This is not, as I said on Saturday with Ben, Donald Trump doesn't do complicated. His crimes and his frauds are the most basic and simple. Ever since the caveman went up to the cave painting and erased one number or horse and drew another one, that's the fraud. And in Mar-a-Lago, he just took documents and then refused to give them back and used half a dozen people to move them around Mar-a-Lago, or maybe move them to Bedminster, and then realized there were cameras and told people to erase the footage. I mean, this is the most basic. I mean, if you were, the two guys in Home Alone 2 that Donald Trump is in, go back and look at it, were more talented burglars than Donald Trump in terms of their more sophisticated plan. What's the plan, Donald? You're going to take 96 boxes and 30 of them that are marked classified, and then you're going to lie to your lawyer and then involve 6 people within your organization to shuffle and then have the boxes delivered up to your bedroom and then look at them and give them to another person and hope everybody keeps your secret? That was your fraud. That was your espionage. And the government has told Cannon in no uncertain terms in papers, this is not a complicated case. There are 30 pieces of paper that are stamped top secret. Even if we don't put on any aspect of the case about the rest of the mound of documents, giant heaping mound of documents, some of which he referred to in that now infamous recording in Bedminster about the pile of Iranian war documents. He had a lot of piles like that. That's National Defense Information documents. That goes to Espionage Act. The government recently revealed in their filing, we may not even go down that route. What is the one term that was used over and over again at the press conference announcing the appointment of the special prosecutor Jack Smith by Merrick Garland? Obstruction. Not Espionage Act, obstruction. The basic nature of this case has not changed from the day Jack Smith was appointed. This is an obstruction of justice case through the hiding and possible destruction of evidence. This is not, it is because it's sexy to talk about it. It is not going to be tried as an espionage case. So we don't ever have to get down to, is this piece of paper National Defense Information? Is this piece of paper? Because the pieces of paper they're dealing with are the ones that are marked classified, and Donald Trump's conduct and behavior, knowing that they were classified and or NDI and hiding them because he wanted to keep them. So he had a revenge file he could use against people like Mark Milley, the then chairman of the Joint Chiefs of Staff, and anybody else, because they've already solved the mystery of the motive. They don't need motive. Everybody talks about motive because it's fun to talk about on that show that you work on, Law and Order. Motive. What's the motive? Why did he kill his wife? What is, or her husband? What's the motive? Is not generally part of the elements of any of the crimes that Donald Trump is charged with. Intent is. But they figured it out on the prosecutor's side. It's not for money. They kind of gave up on the trail of maybe he was going to use the documents in a transactional way to make cash. No. He did it for the way he did it for Mark Milley, where he pulled out the file when and started to attack Mark Milley and seek political retribution against people. It's his revenge pile, and that's why he kept it. That's why he had Hillary Clinton. That's why he had Mark Milley. The French prime minister pissed him off. Netanyahu pissed him off. So he had all these little piles that he was going to keep. The heart of the case is obstruction, not Espionage Act. So it doesn't really, the SCIF is interesting. The SEPA is interesting, but it doesn't matter. It's 30 documents that are marked classified that he held onto and then hid using half a dozen people to do it. That's the case. And she knows it. And she knows, I think, the volume of evidence that's against him, tractor trailers worth. And so while she's bending over backwards on these issues, and she feigns or is really pissed off and upset and takes her gavel home with her. I don't like the way this hearing is going. I'm going to go home. Okay, that's all right. I've had a pissy judge before. I've had a pissy magistrate before. It happens. I'm not sure yet and I'm not in that camp yet. I could be one day, but I'm not now, that trial is going to move off of May. I still believe that she believes, as does Judge Chutkan, that it is important to the American people that the trial of Donald Trump for the criminal matters get tried in public before the election, and that he does it. If he's an innocent man, God help us. If he's an innocent man, that he doesn't have the cloud of that accusation hanging over him either, whether you're on the Trumper side or the side of democracy, right? He needs to get his name either cleared or convicted, one or the other. So I'm not yet in the camp that because of this day-to-day back and forth, tit-tat, cat, mouse in the courtroom about some of these issues, it automatically means we're going to lose the trial date. I'm not there yet. Now, when she does it, you guys can say, remember Popok, remember in October when you told that really cute story, you were wrong. Well, that's okay. I'll be wrong. But that's my view. I'm not yet giving up hope about the stability of that date. Maybe a few more maneuvers, and I'll be wrong. But I know where you and Ben are on this one.
Well, I'll tell you why I don't think it's going to go. Also,
hey, Boogie.
I know, Boogie. Oh, my faithful dog, always here for every podcast.
Hi, Boogie.
Clearly, it's dinner time. I think that first of all, I love your optimism, and I love that you still very much, no, it's true. Like I find it so hard to say anything negative about a judge or a federal judge because I grew up, having so much respect for them, right? Judges are the neutral arbiters. They're the ones who are there to call balls and strikes and do justice, et cetera. And so I really hope you're right. And I hope, I want to think that about Judge Cannon, like I want to think that about every judge. And that's why I said, maybe it's because she's inexperienced, that's why some of these things are happening. But I hope you're right. Although if Judge Chutkan's case starts when it's supposed to start, then Judge Cannon's case will get pushed, probably just because they might still be on trial. So we'll see.
I agree with you. And that's why, to sort of round that out, that's why I love Judge Chutkan, because she was like, let me make a phone call up to New York and talk to Judge Merchan's chambers about the Stormy Daniels case, which is scheduled for March. And I'm going to give him the courtesy. You okay if I bump you and I take it? I'll do the federal election case. Yeah, sure. Judge Merchan, we know this. It was reported that the staffs talked, and she's allowed to do that under the rules and canons of judicial ethics. She's supposed to do that. She didn't make the phone call to Judge Cannon, and she just said, let me see, what's going on? What's the other date you got on there? May? Who's it with? Cannon? I'm going to take March. Because now we know there's definitely going to be, and of the two cases, it's the one that you've always said, Karen, to paraphrase you, it's the one that is the most important case out there, is the federal election interference case, federal style, in home court advantage, Jack Smith in the District of Columbia. I love Georgia, and I love the case. We'll talk about it next. But the one that I'm putting all my money, if I'm at the track and I'm betting on the horses like my old grandfather used to do, I'm putting it on Jack Smith. Mar-a-Lago is really interesting. I like learning about SEPA, and I like learning about, how both corrupt and juvenile and sophomoric Donald Trump's scheme was. But, if God came down and said, you get one, son, pick one that you want a conviction in, I'm like Jack Smith, Judge Chutkan, federal election interference. Put them away, not like, the documents thing. That's why I continue to believe it's the stalking horse used to exhaust the resources and the lawyers. And we're starting to see it for Donald Trump. Let me just leave it on this, then we can go to Georgia, if you're okay with that. Look at how thin these lawyers are spread for Donald Trump right now. You've got Chris Keiss backed up by Alina Habba and a guy I never heard of ever. Mr. Fields, in New York, handling the fraud case of the century against Donald Trump, which literally could strip him bare. And as I said in the hot take, leave him wearing a barrel and suspenders selling apples on a corner. That is in the hands of one lawyer, Chris Keiss, a backup from Alina Habba's firm. I thought Alina Habba was no longer a practicing lawyer. I thought she was a spokesperson for the PAC for Donald Trump, but she's there. That's his entire team. Okay, not 10 lawyers, not a major national firm, 2 people. Then at the very same time, John Lauro, who just joined the case in August, is the lead trial lawyer down in Florida. And what happened to Todd Blanche, by the way? We don't see Todd. He sits in the courtroom up in New York, doesn't say a darn thing. So that's going on. And in Georgia, we're going to talk about next, they brought in, the guy, Steve Sadow, who nobody down here has heard of, hasn't done a darn thing except go, me too, judge, me too. I like what she filed. I like what he filed. That's their entire team against the United States of America and all of its resources, and hundreds and hundreds and hundreds of people devoted to this case from a legal standpoint, investigatory standpoint, and otherwise. And Jack Smith and a Jack Smith team that it's no less than 22 people of lawyers plus junior lawyers behind them and paralegals and investigators behind them. It's working because they can't even be in the same room at the same time. I mean, if Donald Trump thought the brain trust was Blanche, Lauro, Keiss, they can't even be on the same case at the same time. So you're right. That case is going to trial in March. Judge Chutkan made it clear. No doubt. That's going to take more than 2 months. It's going to interfere with the May case. And I'm okay with that. If the reason the May case doesn't happen is because he's on trial in the case in DC, good. But, let's leave it out there. We need one of these trials before November. I think that's the beauty of Legal AF. That give you a taste, give you just one of our 4 or 5 segments every week at the intersection of law, politics, and justice there. Karen thinks, it's almost like a fait accompli that we're going to get rid of the trial date in the Mar-a-Lago case, that trial date of May is going to slip off into the ether, and we're not going to have a case tried for Donald Trump in the Mar-a-Lago espionage and obstruction of justice case. But I'm not so sure. And you heard my reasons why, having been on the receiving end of some rulings that just scratched my head throughout pre-trial proceedings, losing discovery motion after discovery motion, or even substantive motions, and wondering what is happening here. But once I got to trial or arbitration, things turned my way, and suddenly I was getting every ruling in my favor when it mattered, not in practice or rehearsal, but in the game. And that's what you just saw. If you like that clip, circulate it to your friends who may not yet be followers, listeners, and in the audience of Legal AF. If you liked it, also watch our hot takes, these 10-minute, 15-minute clips on cutting-edge issues at the intersection of law, politics, and justice. One place exclusively on, fill in the blank, the Meidas Touch Network. But you knew that. You're watching me here. So free subscribe to the Meidas Touch Network. If you get them to 2 million people, no, you don't get a free t-shirt. Although if you were the 2 millionth, we'd have to look into it. You do, however, get your voice better heard because our grassroots platform will have then reached a point of really, really tipping over and influencing how media treats news in law, politics, and justice. So pass this clip along. Come watch our show if this is new to you. If you're like, who are these two people? What kind of show are they doing? You're learning now. That's an example of what we do. We do these late night Legal AF After Darks for you to get that kind of taste. So until my next hot take, until my next episode of Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.